Hello, this is Matt on the Moon Lambo channel, and I've got a legal update for you in this very latest Moon Lambo hot jam. So I hope you brought some toast, because there's going to be some hot jam all over this bitch. So there's an order from Judge Netburn on 2 motions, one set each from defendants and from the SEC. And attorney Jeremy Hogan pointed out on social media that the SEC is basically being forced to admit that XRP purchasers had no expectation of profit. Now, this is crucial because, as you may well know at this point, investment of money with an expectation of profit. You're talking about those are 2 prongs of the Howey test. Again, investment of money, that's 1, and then 2 with the expectation of profit. The SEC, as you'll see as I go through this, didn't so much want to answer this, and the judge says, no, you're going to answer it. So what I did is, because here's the order right now, it's on the screen here. This thing's 9 pages long, so I printed it up. You can hear it, there's the dead trees in my hands right now. And I highlighted the portions that I found to be most interesting and relevant, and I'm going to run through them with you with some commentary here. But also, and this isn't going to be terribly surprising, I think, to anybody, regarding Ripple's roughly 30,000 requests for admissions, you may recall, and I'll talk more about it a little bit later in the video. Ripple's not getting what they want. I don't think it's the end of the world, and I doubt anyone's seriously going to be surprised. And if you don't know what I'm talking about, don't worry, we'll get to it a little bit later in the video. But I'll just tell you here at the outset, the SEC wins on that front. Unfortunately, though, and I think you'll find it interesting when I read through the specifics. The judge, the way that she worded her response to all this, it seems pretty damn clear to me that she is not happy with Ripple on this front. Seriously, you'll see what I'm talking about. But I do want to be clear at the outset, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about cryptocurrency related topics, but just as a hobby and just for fun. That's all that's going on here. So I want to read this intro portion so you can just see what's basically what's being discussed here. This order, so this is, to be clear again, this is from Judge Sarah Netburn today. This order addresses 2 pending motions. First, defendants Ripple and Christian Larson move to compel the SEC to supplement its responses to 11 of Ripple's interrogatories and 2 of Larson. So just pause right there. As far as the interrogatories, it's Ripple requesting answers on key portions of this case, and the SEC must. This is how it works under federal rules, as I've learned here. The SEC absolutely must reply and in full. You can't just give kind of vague answers, this or that. You have to provide full answers to these interrogatories, and they're crucial to the case, right? Anyway, and the judge continues now. Second, the SEC moves for a protective order to relieve it of the obligation to respond to 29,947 separate requests for admission. Wait till later in the video, though. It's kind of comical, honestly. It's not particularly good for Ripple, but it's not the end of the world, and it's kind of funny. So, anyway. And then she writes, because the discovery sought overlaps in certain respects, these applications are resolved together. Both motions are granted in part and denied in part. So let's go ahead and jump in. So this is page 2 now. Here we go. So this is what the judge wrote. Contention interrogatories are designed to assist parties in narrowing and clarifying the disputed issues and reducing the possibility of surprise at trial. So look, that's just an explanation of interrogatories. The SEC's answers were not to the satisfaction of Ripple, which is what led ultimately to the judge having to pick sides here and ultimately provide an order on the topic here. Well, anyway, she also writes, parties are required to answer contention interrogatories truthfully and completely. I don't know if the SEC knows how to do anything truthfully. They definitely don't know how to do anything in totality, in completion. So you can see why the judge needed to include that there. And then she writes, and responses must be provided separately and fully in writing under oath. And so to be clear, that under oath portion is rather relevant and important, meaning that what they answer here, it's binding. This absolutely can be brought up in trial. Ripple's attorneys can reference this. It's the implications of this are big. So you can understand why the SEC would want to be vague, but they ain't getting away with it here. And then the judge writes, answers should be in a form that may be used at trial. Defendants seek binding representations from the SEC related to the application of Howey to this case, as well as identification of the factual support for those representations. And so that's just a one sentence line indicating in a general sense what Ripple wants. So now let's get to the specifics, though. And this is where it gets really, really interesting here. And I'm going to show you a comment from attorney Jeremy Hogan, who of course runs the very popular YouTube channel Legal Briefs. I'm assuming you all are subscribed, and if you're not, why, like, functionally, what is wrong with you? No, seriously, if you are new and you're not aware of his Jeremy Hogan's channel, Legal Briefs, you should just type that into the YouTube search bar. It'll pop right on up and subscribe. But anyway, the judge writes the following. First, Ripple moves to compel the SEC to identify all terms of the contract that the SEC contends created an expectation of profits for each contract the SEC listed in response to a previous interrogatory. And so basically what's being referenced there is Ripple's XRP sales. Now, mind you, Ripple, for the entirety of their existence, has never sold a single XRP to any retail consumer. It's been sold... It's been sold. They've sold to key partners, especially as it pertains to on-demand liquidity, liquidity management, all that stuff. But they've never sold to the individual like us. And my understanding also, and this is not relevant exactly to this, but it's worth mentioning, the sales. My understanding is that well, certainly as it pertains to Brad and Chris. Those either 100% or just about 100% of those transactions occurred outside of the United States. So if there's any exception to that for Ripple, the company here, then it would still be minority. But even then, again, it's not to like retail speculators like you and I. And so then the judge writes the following. This is the money part. This is what Jeremy Hogan ended up commenting on. And this is not good for the SEC. Check this out. Ripple interrogatory number 2. The SEC opposes on the grounds that the interrogatory assumes by its lights an incorrect reading of applicable law, and that the contours of investment contracts under Howey need not come from contracts alone. The SEC's legal theory is not an excuse to avoid responding to defendants' factual inquiry. So just pause right there to note the judge ended up finding their response or their excuse here not satisfactory. They were dodging the question because clearly they didn't want to answer it. The judge is not having it. And then she writes, nor is it a basis to answer a different question than posed. Like that too. Ripple's interrogatory is relevant and precise and will clarify whether the SEC contends that the terms of any contract identified in response to Ripple's interrogatory number 1 created an expectation of profits by the purchaser of XRP. See, so let's pause there to note that that's a big deal. We're talking about the actual sales of XRP. Does that mean that there's an expectation of profit for people like you and I? Well, clearly the answer is no. I don't know about you guys. Yeah, I do actually. We're all the same. I wasn't accounting on Ripple to impact the price of XRP. What I count on, I mean, certainly not directly. The greatest impact I could say they would have in my thinking is that I just want a variety of actors within the space and a healthy ecosystem, because a number of developers building on top of a platform, yes, that I think is going to result in long-term viability and price appreciation. But this idea that it's just I bought and I'm buying it because I expect Ripple to do so-and-so and price will go up. No, that is not what I was expecting. And I know that I'm speaking for the entire XRP community here, because it's very clear that very close to 100% of us feel exactly the same on that. And then the judge writes, accordingly, defendant's motion regarding Ripple interrogatory number 2 is granted, and the SEC must supplement its response to interrogatory number 2 to identify any specific contractual terms and not just implicit and explicit promises as previously identified. And so that's what the SEC previously stated when pressed by Ripple to provide an explanation of how there are any specific contractual terms between, for instance, yourself and Ripple. Instead of providing any specificity there, they just made the claim, and then they said that it is, quote, implicit and explicit promises, end quote. That's what the SEC said, and the judge ain't having it. That is not specific. And look, here's the deal. There are no specific contractual terms. The judge just called out the SEC on their vagueness, which really, the vagueness, it's been a hallmark of the SEC's claims against Ripple. As vague as they can be, as vague as they can get away with, that is exactly what they're going for. They don't want any specificity because they don't want to be backed into a corner of their own creation. So that's what's going on here. And so here's what Jeremy Hogan had to say on this, because he highlighted a big chunk of that portion I just read to you. And Jeremy Hogan wrote, the SEC is going to be forced to admit that there is nothing in any of these contracts that created an expectation of profits by purchasers of XRP. That's a big problem for the SEC. And then he also wrote, and also most of Ripple's requests for admission were stricken, but we expected that, with a little smiley face. Yeah, I'm not surprised by that, at least. We'll get to that a little bit later in the video. But yeah, there we go. This is a big problem for the SEC. Because again, you're talking about an entire prong of the Howey test. And there's nothing to point to. Because again, the judge is demanding, no, specifically. Where's the contract stuff? Where is that? Folks, it doesn't exist. It doesn't exist. Which is why I've been saying, like, the facts and circumstances, let's look at them, because they're on the side of Ripple, and it benefits XRP holders. Just the reality of the situation, it's good for XRP holders, and it's good for Ripple on the whole. And so, that's why I keep saying, as long as there's a sufficient outcome, a proper outcome in terms of justice, yeah. I mean, if you just look at the facts, like, what would you expect to occur here? Then moving on, next page here. Here we go. Third, Ripple moves to compel the SEC. Let me move down here. Which page am I on now? 4. I gotta get down. Here we go. Third, Ripple moves to compel the SEC to state whether it contends that efforts by Ripple were necessary to effect any increase in the price of XRP. Defendant's motion regarding Ripple interrogatory number 11 is granted. So there we go. Did Ripple impact the price of XRP? Look, if the SEC says yes, they're kind of toast, because again, let me read this sentence again. Ripple moves to compel the SEC to state whether it contends that efforts by Ripple were necessary to effect any increase in the price of XRP. So Ripple wants to know, SEC, XRP price movement. Did we make that happen? We're Ripple. Did we make the price of XRP go where it went? Yes or no? And if the SEC says no, well, that's not helping their case, because it's a security of Ripple, right? XRP is a security of Ripple. Of course they're tied together. So if they say no, that's bad. But if they say yes, they're toast. The reason is there is irrefutable data proving that XRP moves with the crypto market and not based on Ripple's efforts. Now, anybody that's been in the community for, say, even just the last few years or so, you'll know that this is true. There have been, as long as I've been in the community, which is November 2017, there's been an endless number of people upset with the fact that there's endless good news surrounding the adoption of RippleNet and the adoption of XRP, real-world utility, having to do specifically with Ripple, and it doesn't move the price of XRP, and people within the community not understanding, for a lot of people not understanding for the longest time, that the market just moves together because it's in its nascency, they're upset with this fact. So anybody that's been in the community for a number of years will know this to be true. And this is part of Ripple's actual legal argument. So whatever the SEC says about this, the implications are big, and there is no right answer for the SEC. I mean, there's a right answer. That's what the truth is, but there's no answer that's going to benefit the SEC. That's the right way to word it. Then this continues. Here's what else the judge wrote. Fourth, Ripple moves to compel the SEC to identify the enterprises or ventures, if any, in which the SEC contends XRP holders acquired a stake in by virtue of their purchase of XRP from defendants. Ripple interrogatory number 17. And so this is that you may have heard Brad Garlinghouse and other executives at Ripple over the years, when asked, is XRP a security, would the SEC think that? And he said, well, no, of course not. Purchasing XRP, it doesn't mean that you somehow own a stake in the company, which would be the case if you purchase like Apple stock or something like that. Of course, you don't get any sort of ownership rights or anything like that. And so defendant's motion regarding Ripple interrogatory number 17 is granted, this is what the judge wrote, only insofar as the SEC is ordered to supplement its response to comply with Rule 33b3. And so here the judge is saying the initial SEC response is not sufficient and further details must be provided. And, their attempt to avoid providing detail has failed. That's what to take away here, because part of this rule 33, B3, it states part of what I was saying a little bit earlier in this video, which is that you must provide complete and sufficient answers, and the judges found that has not been the case here. So try again, SEC. Next page here. Go on to number 5. Here we go. Oh, this was interesting, actually. So the SEC is getting away with something for now. We'll see how this goes, but this is important, too. Check this out. 6th, Larson moves to compel the SEC to contend whether the XRP ledger was not fully functional before the start of the ongoing securities offering alleged in the complaint, and if that is the SEC's contention, identify when the SEC contends the XRP did become fully functional, if ever, and what actions or efforts resulted in making the XRP ledger fully function. So just pause right here to note that we know that the XRP ledger was fully functional before Ripple, the company, ever existed, by a number of I don't remember exactly what was on the top of my head. It doesn't matter. The point is, we know that it was live. XRP existed before, and so as far as this idea of functionality, and this is a crucial aspect, because there's a number of reasons, not the least of which is if you think about who was the SEC targeting, and who did the SEC publicly state they were going to target in 2017? ICOs. That's what they were calling it. Ethereum style, money grabs, because Ethereum had an ICO obviously back in 2014, and in 2017 there were so many of them, the SEC made it clear they were going to go after that type of activity, because what was typically going on was money was being invested to create something. So clearly there was an expectation of profit and to build something out. In the case of XRP and the XRP ledger, well, no, Ripple had nothing to do with the creation of the XRP ledger. That's just a fact. And so here, Ripple wants the SEC to answer whether or not the XRP ledger was fully functional at any point. And then, anyway, judge continues. Larson interrogatory number 5, the SEC opposes on the grounds that the information sought is irrelevant and that the term fully functional cannot be defined without parameters for functionality and clarification of the perspective of the person measuring functionality. So pause. The SEC saying, no, we can't answer this because we don't know what fully functional means. How do we find, if something is fully functional or not without having parameters? Which actually does, honestly, that part does sound reasonable. But this, in conjunction with everything else that they were avoiding, I'm still just like, suck it, SEC, I just don't care. But and so then the judge wrote, defendants counter that the SEC's own public-facing website states that whether a digital asset is not fully functional at the time of the offer or sale is relevant in a Howey analysis. The court agrees that this interrogatory seeks relevant information, but defendant's interrogatory is too vague for the reasons identified by the SEC. The parties are ordered to meet and confer in good faith to further clarify the terms of Larson interrogatory number 5 and facilitate resolution of this dispute. Defendant's motion regarding Larson interrogatory number 5 is denied without prejudice here. And so, given that the SEC, well, actually, all of them agree, frankly, because the SEC stated on their own website that whether or not something is fully functional at the time of offer or sale matters. Ripple just wants clarification on that, and then the judge says, yes, it's relevant to the case here. So it's kind of like, the way that the SEC should be answering this really is just, it would be the same way that they'd explain what's on their website, like what constitutes fully functional. They're saying that Ripple hasn't, they and Ripple don't have some sort of understanding at this point in time of what constitutes fully functional. Well, why not just go by what the hell the SEC says on their website? Because they're saying that matters. So you would think, presumably that's the direction that Ripple's attorneys would go in trying to figure this all out. But anyway, for now, the SEC is successfully avoiding answering this question, but looks like the judge is going to want some sort of resolution of this, and they're hoping that the parties can work it out, the defendant and plaintiff here. So we shall see. And then this on page 6. And this is where the SEC kind of wins a little bit. But it's not that big a deal. It's really not that big. You'll see what I'm talking about here. And they don't entirely win either. Both parties have relied extensively on the use of requests for admission. So let me just pause right there. For those of you that have missed any sort of content on this from me or any other article or blog or YouTuber content out there, the request for admission, this is just something that's, and I don't have a legal background, so I'll just try to not word this terribly sloppily, but when it comes to legal matters such as this, a part of the procedure, pre-trial procedure, is asking the other side a bunch of questions. So requests for admission. It can be fairly non-consequential things, just to make sure that there isn't any sort of dispute once you get to trial. It's to try to make sure that the trial's, it doesn't lag any longer than it actually needs to. And it could be something simple. The car that was in the accident was blue, yes or no? And so get them to answer just a bunch of questions like that. So it'd be really quick. A lot of them you don't even necessarily have to put a bunch of thought or research into. It's just it's true or it's not true, and then it's just making sure you're on the same page with the other side on key facts of the case. That's pretty much it. And so here you go. Both parties have relied extensively on the use of requests for admission. On the last day of fact discovery, defendant served the SEC with 3 additional separate sets of requests for admission. The 4th set contains 776 requests and are primarily concerned with defendant's fair notice defense. The 5th set contains 309 requests and are primarily concerned with defendant's extraterritorial defense. Now, this is the fun part. The 6th set contains 28,862 requests and is itself 4,923 pages long, which is, like, I don't know if you guys respond the same as me, but to me, that's funny as hell. Like, that is ridiculously long. And I've come to understand, in getting opinions from attorneys that are within the XRP community, that this isn't particularly normal. So take that for what it's worth. This many requests, this many pages, not particularly normal, but this is what Ripple is seeking. Requests for admission, so almost 30,000 freaking questions on thousands and thousands of pages, and the SEC isn't too thrilled about that. They went on to cite, as I've covered on this channel, that's too burdensome, right? And Jeremy Hogan actually highlighted this too. He mentioned publicly on Twitter that, in his cases, when they're going through the request for admission segment of the case, that normally has, like, I think he said 25 or 30 questions, somewhere around there. So nowhere near 30,000, let's say. So check out this, because this did not go well for Ripple, and you'll see here the judge seems to be not too thrilled with Ripple. So check this out. This is what she wrote. Lastly, the 6th set of requests returns us to the disputed issue of whether defendant sales of XRP constitute investment contracts under Howey. Defendants ask the SEC to consider over 1,500 contracts and answer 13 preliminary questions. Unless an unqualified admission is provided, which the SEC represents it cannot do, the SEC must respond to the subsequent 28,849 requests. And this is the key part right here. Check this out. Despite the defendant's protestations that this volume of requests is reasonable and will narrow the issues for trial, it is hard to view this stunt as anything more than theater. Ouch. The motion for a protective order is granted on burden grounds. Ooh, so she called what Ripple did here a stunt in theater. Not exactly ideal. She hasn't worded anything that harshly against the SEC that I've caught anyway. So it definitely stood out to me. Not that it's necessarily going to matter in the end. It kind of is what it is. But primarily what I'm seeing here through all this, it's by and large very good for Ripple. You're forcing the SEC, which loves being vague, to actually answer hard-hitting questions, which really are key. I don't know how you cannot answer these and make these claims against Ripple. You can't reasonably do so, because it has to do specifically with the core of the matter. Is Ripple's sales of XRP past and present, frankly, even though I know they're saying through 2020, do they represent investment contracts? Are they securities? Are they securities transactions? Well, you can't conclude that without acknowledging the facts and circumstances of this case, and frankly, they're not. They haven't been. They've been dodging, as I've highlighted in this video. They don't want to answer, and the judge says, no, you've got to answer. And that's what I'm saying. No matter how they answer these questions, I find it a virtual impossibility that the answers are going to result in the case proceeding in a way that's favorable for the SEC. That's very hard to believe. So this all is damaging to the SEC's case. So we'll see what happens. I'm most excited to see, cautiously optimistic, I'll say, to see how the judge rules in terms of Ripple's fair notice defense. That's a big, big deal. If that's not going to be considered in the case, if that's not a legitimate defense, we got a problem. And I'd be less confident in any sort of settlement. But if we do find out that Ripple's fair notice defense stands, I would think, it's my unprofessional opinion, but based on what I've heard from attorneys within the community, I would think the odds for settlement increase dramatically. So we shall see. But that's what I got for you. I'll wrap up here. I'm not a financial advisor. You should not buy or sell anything because of anything that I say are right. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.